session of today's conference. At that time, you may press star, then the number 1 on your phone to ask a question. I would now like to turn the conference over to Patrick Shepard. Thank you. You may begin.
Thank you, Jennifer. Good morning and welcome back to our Public Financial Disclosure Massive Open Online course. My name is Patrick Shepard, and I'm very pleased to be joined again today by Mark Stewart from OGE's Compliance Division. So in the second part of our Massive Open Online course, we're going to take the knowledge that you developed and learned yesterday from Mark, and we're going to put that to work through an exercise. Hopefully you've had an opportunity to take a look at the exercise. If not, I think this exercise will still be helpful for people to follow along with so that they can get some experience with the public financial disclosure review process. We are going to have time for a question and answer period at the close of today's session. For those of you on the Hangout, if you're using Google+, you can type your questions into the lower right-hand corner of your screen, and we will address those during the question and answer at the end of the presentation. For those folks on the phone, the question and answer will be moderated at the end of the presentation. So if you have questions, please make a note of those because we want to get to as many as we possibly can. We'd also like to remind everyone that we will be back here at 2 p.m. today for our regularly scheduled Fundamental Series broadcast, where members of our presidential nominee branch will be discussing recent changes to the Public Financial Disclosure Reviewers Guide. You may have seen the announcements for that new guide, and we're going to be walking you through some of the changes to that guide and new policies and such. So do join us for that. Mark, would it be helpful if we just jumped into the exercises and get underway?
Yes, definitely.
Excellent.
Okay, well, thank you very much, Patrick. Once again, what we're going to do now is just go through the exercise, which was in your handouts, and hopefully you have it available either as a printout or online if you're really young and know how to do that stuff. I also hope that you did take the time to try to go through it just so you're a little bit more exposed to the 278 form. And if so, great. And if you have questions, we'll handle those later. Otherwise, let's go ahead and get started. Okay, first is the cover sheet. And our filer at our imaginary agency is called James Nicklick. He is the Assistant Secretary for Procurement at ABC Agency. Going down one line, he has no other federal government positions held. Going down one line, he's not being named as a nominee to a congressional committee. And going down one line below that, we see that our filer has not actually signed or dated the form. This happens. Filers don't want to do this. They don't want to deal with it. It's just something to get off their desk. So we know that we're going to have to go back to our filer anyway to at least have that done. But as long as we have the form in our hands, what we're going to do is review it. That way, when we do go back to the filer, we can hit them all at once with all of our questions. Okay, below that is where we will sign it or where our bosses will sign it when it's certified. Below that, if your agency has any intermediate review that they'd like to track, that's where that would be signed. Below that is where, as I indicated yesterday, for our PAS types and for your DAO, those reports are also forwarded to OGE, and that's where we certify them. Below that is the space for any comments that you would have. Okay, now let's go up to the top left of the page. Where we see it says report type. Our filer is an annual filer. Our filer should have filled in the year below that, and it should have been 2015 for this year. Below that, we see that our filer was appointed in 2013, so he's still fairly new for us. Okay, let's go to part, whoops. Why is that? Oh, why is that going backwards? Okay.
Excellent. Well, let me take just a second, Mark, and I will get your exercise up. It appears that the deck we have here just has the first page. So just a second, and we'll get that up.
Okay, I apologize for that.
No problem. If you want to start taking people through the first page, you can do so while I get that on.
Absolutely. If you look at the next page of the handout, it should be part 1. The first thing we notice is that our filer doesn't have his name and the page number on the top of the form. That's not critical, but quite frankly, we recommend that you fill that in if it hasn't already been filled in electronically by the form. Below that, part 1, as we discussed yesterday, this is where the filer enters any outside positions. And once again, this was designed to capture this information for new entrant filers. Our filer is an annual filer, but still, we'll take a look at what he has reported. And the first entry is Valley Park Condo Association. The city and state is Scotia, New York. The type is a homeowners association. The position held is vice president from 1989 to the present. So technically, that's filled out fully and correctly. For our conflict of interest analysis, apparently he has a condo and is in a condo association. We would have to make the determination as to whether or not that poses any conflict of interest with his particular duties. It's kind of doubtful, but as I indicated yesterday, if this is new to you, if you're seeing it for the first time, it might be worth going back to the filer and say, what do you do there? Could your duties possibly affect the condo association, et cetera, et cetera? Okay, now let's go on to the next entry. It is the Electric Coalition of America. The city and state is blank. It's a trade association, and our filer is a consultant and has been from last year, 2015, to the present. If you don't know about this, that's kind of a big deal. It's not very common that our filers are allowed to take consultancy positions with outside entities. First off, technically it's not filled out correctly, but we're sort of beyond that at this point because we need to go back. Thank you. We need to go back and talk to our consultant and say, what is this? As I indicated yesterday, a lot of agencies have outside position permission requirements, and we definitely did in the Coast Guard. So if you already know about this and it's been cleared with your filer's boss and everything is okay, then that's fine. But if you're seeing this for the first time, that's really a big deal that you need to get resolved right away. Okay, let's go on to part 2. Thank you. The filer's employment, assets, and income. And once again, we see that the filer has listed the Electric Coalition of America and is getting a salary from the outside position of presumably, thank you, a consultancy fee, and has reported an exact amount of $5,000. Once again, technically, this is reported correctly, but for our conflict of interest purposes, once again, we need to go back and find out what's going on, why our filer is working this outside position with the Electric Coalition of America. Okay, next, please. Part 3. This is where the filer reports any employment agreements and arrangements. And our filer has reported a party of E&E Engineering from Albany, New York. And the status terms are, upon reaching age 65, I will receive $10,000 a month for life. And the date of that agreement was July of 1976. Okay, first off, as we discussed before, this looks like a defined benefit plan, and that's great. Presumably, our filer worked in the private sector and then came into work for our agency. We probably already vetted this, and if he can take any official action that can put E&E Engineering out of business and therefore affect his future pension, then we have a potential conflict there. However, from a technical point of view, what we need to find out is why is this not reported on part 2 as an asset? And if our filer just inadvertently omitted to report it, we can get his permission and go back and make a pen and ink change. Or since we're going back to the filer anyway, hopefully we can have him track through everything.
Yeah, Mark, I've noticed recently that we see fewer and fewer of these defined benefit plans and more of the defined contribution plans like the 401ks. In those cases, it would be important for us, right, to make sure the underlying holdings rather than just the report were reported on part 2. Is that correct?
That's correct, Patrick. And we talked about that when we went to this part yesterday, but that's always a good reminder. If you see something that's not fully explained on the form, you essentially have to go back to the filer and resolve any issues.
Yeah, that distinction took me a long time to sort of internalize and sort of recognize, because I tend to think of, retirement's just retirement.
Looking forward to it. Okay, if we could go to part 4.
Sure.
This is going to be easy for us because this only applies to new entrant filers. As you recall, we discussed this yesterday. What we're looking for there are client lists from people coming, usually attorneys, accountants, lobbyists, people coming into the federal government service. But now that our filer's an annual filer, we can just ignore it. Okay, let's go on to part 5. This is where we have the filer list any spousal employment assets and income. And let's take a look at entry 1. Our filer reports that the spouse has a job with Clark Incorporated, and the income type is salary, and the income amount is blank. And that's okay, because we just need to know the filer's spouse's outside position. We don't need to know the exact amount of the spousal salary. However, if we're seeing this for the first time, then we have a bunch of questions. Once again, if this has been vetted before, when our filer first came on and reported that the spouse had an outside job, that's great. But if we're seeing it for the first time, we need to go back. We need to find out the type of job. We need to specifically find out if there are any other perks or benefits which should also be reported as assets and income. For example, if the spouse just works in the IT shop at Clark Inc., just gets a salary, that's it, then that's fine. But if the spouse is a high-level executive at Clark Inc. and has stock options, bonuses, other benefits, other pension plans there, we need to know that. And yes, it's very intrusive to ask our filer that, but we need to know it.
Do you find, Mark, that this is an area that people frequently underreport? They'll report a spouse's salary, but then neglect to report the associated benefits, like you just mentioned.
Yes, Patrick, as we discussed yesterday, one of the reasons that OGE broke this out separately was the concern that filers, when they filled out this form, were just essentially walking through it and weren't giving enough thought to possible repercussions or other possible connections that their spouses and they could have with their employment. Most people just don't have that information at their fingertips. Okay, so let's go on to entry number 2, the 401k. The filer checked that it's an EIF and does give a value, does not need to give income type, and also indicates that there's none or less than $201 in income. Well, the first thing is that we remember from yesterday that the 401k is just a holding entity, so we need to go back and get any underlying assets. Also, the 401k itself is not an EIF because the filer has control over the underlying assets. So once again, we're going to have to go back to the filer and get this information about the spouse. And while we're doing it, we'll ask, as part of our questions on entry 1, does the filer have any other pensions related to employment? Okay, let's go on to part 6. And this is where the filer reports other assets and income. And once again, I want to emphasize, since our filer is an annual filer, we can compare this to the prior year's report. If the entries are the same and the filer's duties have not changed, that's going to simplify our job quite a bit. Let's take a look at entry number 1, IBM stock. It is not an EIF since it is stock. We do have a value, we do have an income type and an income amount, so that entry is technically sufficient. Our only concern then would be if our filer could take any official action that could impact the value of the IBM stock. It's kind of like the story I told yesterday about Marvin Runyon and the Coca-Cola stock. If this is just part of our filer's portfolio, then we're comfortable with this.
So the question we'd be asking here is there a nexus between Mr. Nikolich's responsibilities and IBM? Like, would he be purchasing things from IBM? Does he regulate or investigate IBM? Are there any things at work that he might do that could intersect with IBM? That's kind of where we would come up with our concern.
That's correct, Patrick. Thank you. Okay, entry number 2, Fidelity Puritan Fund. Our filer has indicated that it is an EIF, has given a value, has, once again, does not need to give an income type, and has given an income amount. Once again, this is technically sufficient. If we're new at this or we're not sure about the family fund name, we could always just jump online and we would discover that there is actually a Fidelity Puritan Fund, and it's a diversified mutual fund. And so once again, OGE has determined that pretty much it's not going to be a conflict of interest. So we can just move on.
So that's going to be covered by our regulatory exemption, provided that it's a diversified mutual fund, right? We have an outright exemption for those guys.
That's correct. And as we discussed yesterday, that's covered at 5 CFR Part 2640. Okay, for entry number 3, Ing Pioneer Growth Opportunities, our filer left the EIF block blank, but did give a value and did indicate that it earned less than $201 in income. If we're not sure about what this is, once again, we need to go online and track it down. Or in the alternative, if it's really, really arcane, then we'll have to go back to the filer and say, what is this? Hopefully our research will indicate that it is an EIF, because it definitely looks like a holding entity and not a stock. But if it does not qualify as EIF, we'll need to list out the underlying holdings. So we're just going to table that one for now and add it to the list of questions that we're going to go back to our filer on. Okay, entry number 4, Nationwide Managed Account. Our filer indicates that it's an EIF. We have a value, we have an income type of dividends, and an income amount. If we're new to financial disclosure review and we're not very financially articulate, we may not know what a managed account is, but I can tell you this right now, it's a big deal. And it is not an EIF. So we're definitely going to have to go back to the filer and say, first off, what's in your managed account? Because you have to break out and list all the underlying holdings. A managed account is essentially a deal with a brokerage company where you give the brokerage company permission to buy and sell underlying assets on your behalf. That's great, but you have ownership and eventually knowledge of the underlying holdings, and they could be a potential conflict of interest, but you may not know it yet because you haven't gotten your brokerage statement and you don't know what the underlying asset is. For OGE purposes, for the most senior people, we essentially advise them to divest of managed accounts because there's just too much of a risk of a potential conflict of interest. On the other side, if you want to keep your managed account and are willing to enter into an agreement with the managed account such that that broker will only purchase diversified or sector mutual funds or will only diverse stocks in certain areas, that's sort of a risk that the agency is going to have to discuss with the filer.
I think, this is an area where we've had kind of mixed results. So I found a lot of these managed accounts are organized by the financial houses, and they trade the portfolios of many account holders in the same way. and they get a lot of efficiencies out of that, and it can be a good deal for investors. But the result is sometimes they are less willing to make kind of personal adjustments to the portfolio for an individual account holder. So sometimes you'll find that your filers go back to their account managers and say, you know, I work for a defense agency, and I need you to not purchase any stocks or funds that are involved in the defense sector. And we found that some account managers aren't able to comply with those requests.
Absolutely. And once again, if you do see a managed account indicated and you haven't seen it before, if your agency has not already vetted it, you're going to have to go through the process that Patrick just explained. Okay, let's go on to entry number 5, IRA. It is not an EIF. We see that it's worth over $50,000, and we have an income amount of none, which is a little curious. But once again, remember from yesterday's training, the IRA is a holding entity. The filer correctly indicated that it is not an EIF, but we need to go back to the filer and find out any reportable underlying holdings for the IRA. And since it's worth over $50,000, it's highly likely that there are underlying holdings. Now, if we vetted this before and it turned out that the IRA was just a cash account, for example, then we have a technically sufficient and correct entity and report, and we don't have to worry about any conflict of interest. But if we're seeing this for the first time and we haven't vetted it, then we need to go back.
Yeah, I always like to look at the notes from whoever reviewed the reports last year to see kind of if any of those questions are answered for us already.
Absolutely. Once again, that's one of the reasons we recommend you keep good records on your filers, because it's easier to resolve it just by looking at the prior report and the prior report notes than having to go back to the filer and reinvent the wheel. Okay, let's take a look at entry number 6, the Virginia 529 plan. It is not an EIF. It has a value. It does not have an income type. That's fine. And we do have an income amount of none. As we discussed yesterday, 529 plans are college savings plans. They're sort of like 401ks, and they're set up similarly. And OGE has relaxed the reporting requirements for certain types of 529 plans. What you would need to do if you are seeing this for the first time, quite frankly, is jump online. And if you can track down the particular 529 plan online, the filer doesn't have to report all the underlying holdings. However, you need to do your homework in that area. And once again, OGE does have a specific advisory opinion on 529 plans. So if you're seeing this and it hasn't been vetted, I recommend you look it up. Okay, entry number 7, New York Stock Exchange LUV. The EIF block is not checked. We do have a value, and there is no reportable income. The takeaway from this is that this is a ticker symbol. If you're familiar with the concept of ticker symbols, that's how the stock exchanges have abbreviated essentially initials for companies, et cetera, et cetera. For reporting purposes, the ticker symbol alone is not sufficient. OGE has determined that, first off, if you're just typing in 3 letters, a requester for your report really doesn't get the underlying name of the asset. And that's one of the reasons we do public financial disclosure, for that transparency. Also, it's really easy to make a typo error if you're just dealing with ticker symbols. So the bottom line takeaway from here is, if you see an entry and it's just a ticker symbol, it's going to have to be remedied. We're going to need to know at least the name of the entity.
So since we're going back to Mr. Nikolic anyway, we might be able to look up company LUV and post the question to him. You've reported this symbol. Can you confirm that it is this company? Or if it's not, tell us exactly which company it is. Is that kind of how you'd approach that?
Absolutely. Absolutely. Okay, entry number 8. The filer reported a savings account, which we would presume is a cash account. It's obviously not an EIF. Its value is reportable for a savings, for a cash account. The income type we don't need because the income amount is none or less than $200. The takeaway from this is that the filer did not name the bank where the account was held. This is new. It used to be required that we needed the name of the savings institution, but as they're going to discuss today at 2 o'clock, OGE has determined that there's sort of a identity theft risk if a reviewer of, or excuse me, not a reviewer, if a requester of a report knows the filer's name and knows where the filer's bank accounts are, there could be a higher potential for possible identity theft. So the bottom line is, on the old reports, we needed the bank or savings institution name. From this year going forward, that's no longer required. And you might want to use that as a training point for your filers.
Yeah, that seems like something that would be good to remind people of, maybe with the request for new filing, or whenever you're contacting filers.
Absolutely. They're not going to know that until we tell them. Okay, so let's go on to part 7, transactions. Entry number 1 is IBM. Our filer reports a sale during the reporting year and gives an amount. Let's combine that with entry number 2, which is General Electric, which is a purchase. Once again, during the reporting period calendar year of a fairly large amount by my financial standards. Our first question is, did our filer report this already on a 278T? Since these are securities and are not EIFs, therefore they would have to be previously reported in July and in June and August, or within the reporting period, on a 278T. If we have the 278Ts, great. If we don't, we have a potential issue because that was required. We're going to have to go back to our filer and find out what happened, and then determine whether or not we're going to charge our filer a late filing fee if there are no 278Ts. Also, for a purchase, the GE should be on presumably Part 6, or if it was purchased by the spouse or the filer as part of their employment packages, then it would be on Parts 2 or Part 5. Okay, entry number 3 is the Vanguard Standard & Poor 500 Index Fund. We can sort of assume that that's a mutual fund and would be an EIF. We see a purchase in the reporting period of a reportable amount. That's fine. That doesn't require a 278T. But once again, we would expect to see that on Part 6 or Parts 2 and 5, respectively. Okay, let's go on to Part 8, liabilities. Okay, the first entry is Bank of Albany, and it's a mortgage of a certain amount. It was incurred back in 2003. We have a rate and a term, so technically that's sufficient. But our question is, if we're seeing this for the first time, is it a mortgage on a home that should have been reported if the father was a PAS? Is it a mortgage on property that used to be residential property but now is rented out? If so, we need to know that. In other words, if we're seeing this for the first time, we need to do a little digging. Okay, entry number 2, Bank of Scotia, mortgage on a rental condo. We have an amount, a year, a rate, and a term. Once again, that's technically sufficient, but if our filer has had this rental condo for a while, that should also be reflected on Part 6 as an asset. If it's not there, we need to go back and find out why not. Okay, entry number 3, American Express. It's a revolving charge account. We have an amount, the year incurred, the rate, the term. Technically sufficient. It's obviously an American Express debit card. Doubt that it's going to be a conflict of interest, but once again, Congress made the reporting requirements, so it has to be reported anyway. Okay, let's go on to part 9. This is where our filer reports gifts and travel reimbursements. Entry number 1 is Castle Associates, Albany, New York. It was a 14-karat gold pen and pencil set and paperweight worth $300. Okay, technically we can see that our filer over-reported this because we remember from yesterday that our gift amounts change every 3 years, and the current amount is $375. However, now we know about it. Now we need to go back, and if it turned out, for example, that Castle Associates was a prohibited source for our agency, if they were one of our contractors or we regulated them or they wanted to do business with our agency, we'd have to go back to our filer under our standards of conduct and say, why are you getting this gift from Castle Associates? If it turned out that the gift was inappropriate, then we would have to remedy that. Either the filer could return the gift or pay the fair market value, donate it to the office, et cetera, et cetera. In other words, now that we see this, we have to resolve it. We can't just let it go.
We can't just ignore it because it's over-reported. We still have an obligation to sort of follow through and resolve the ethics concern.
Absolutely. Okay, entry number 2, Electrical Energy Institute. We have a city and state. We have a very brief description of a conference in San Francisco, California. Once again, remember from yesterday, we need a little bit more than that, as it appears to be some sort of gift of travel. We need a brief itinerary, including the dates. Its value is definitely above the reportable level. Looking at this for the first time, we might want to wonder if this was actually over-reported, if this conference at the Electrical Energy Institute was an official visit or was paid for under 1353, then it would not be reported. It's not really a gift to the filer. However, if it turned out that this was attendance at a widely attended gathering, then it would be reported, and hopefully we're the ones who gave permission for the attendance at the widely attended gathering, so this is not a surprise to us.
When I was in an agency, we kept the financial disclosure physical files right next to the advice and counseling files. So I found it to be very easy to pull the employee's advice and counseling file and see if we did a 1353 authorization or an official duty authorization for these kinds of things.
Absolutely. Absolutely. And once again, as we discussed yesterday, usually it's the legal office that handles all of those things. So everything is in the same file, hopefully. Okay, that's it for the exercise. At this point, perhaps we could open up the floodgates for questions.
Absolutely.
Thank you. We will now begin the question and answer session. If you would like to ask a question, please press star 1, unmute your phone, and record your name clearly. If you need to withdraw your question, press star 2. Again, to ask a question, please press star 1. It will take a few moments for those questions to come through. Please stand by.
And again, those of you who are participating on the Google Hangout, you can ask a question by typing it in the question and answer widget at the lower right-hand corner of your screen. While we're waiting for the first question mark, I think question mark.
You kill me, buddy.
I think this exercise is a very good one because probably 95% of the errors that we see are the same errors over and over again, the same instances of underreporting.
Mm-hmm.
So these things, the reporting of the IRAs, the retirement account reporting, those kinds of issues are the things we're most likely to catch. And as a new reviewer, if you can be aware of those kind of top 10 or top 15 most common mistakes, you're going to get most of the way to a complete and thorough report that you can conduct a good conflicts of interest analysis upon.
Absolutely. Absolutely. And one thing I indicated yesterday that we were going to touch on briefly today, and we might as well do it now and get it out of the way, are potential remedies. And in your handout, I have a list of them at slide 94. If you do find you have an issue, you need to discuss a remedy with your filer. By all means, if you're dealing with a PAS filer, they're kind of senior. You might want to get your boss involved, the
Right.
general counsel, et cetera, et cetera. And the remedies are talked about on 5 CFR 2634.801. And essentially they're a recusal where the filer just doesn't take any official action, then bang, there's not going to be a conflict of interest. The next item is a divestiture where the agency requires the filer to get rid of a particular holding. That can be a big deal, but it can also be mandated by the agency as a condition of employment. Resignation usually refers to resigning from an outside position, which is problematic. But once again, it can be mandated, or the filer could just resign from federal government service.
So they always get a choice, right?
Yes, yes.
One or the other position has to go.
It's
in some cases.
Some days it looks a lot more attractive than other days. Below that is a change of assignment. If you come from a very large agency and you could absorb that sort of hit, that's fine. If you're in a small agency, that's probably not going to be that much of an option. The next bullet is a waiver. And I mentioned this briefly yesterday. Agencies have the authority to actually waive a conflict of interest. As you might imagine, that's kind of a big deal, and it has to be floated by OGE. And the main reason for this is that the Department of Justice does not look kindly onto agencies saying it's okay to violate a federal criminal statute. So there are a lot of hoops to jump through. If you're contemplating a waiver to allow somebody to continue their job, even though they have a conflicting holding, talk to your desk officer and get that process started. Below that are the qualified trust, blind or diversified. We talked about this a little bit yesterday. Back in the day, it was a recruiting tool where somebody coming in from the outside who had a lot of assets, some of which could be problematic, could create a trust such that they wouldn't have control over those assets anymore. It seemed like a good way to get people in and not have them be in a continuous potential conflict of interest. This ended up being problematic mostly because the people who are rich probably got there by keeping an eye on their money, and they don't like giving up control of it. Also, once they realize that any potential conflicting asset has to be divested anyway, then they're like, screw that. So once again, I'm not aware of any of these currently in the federal government, and I think in my tenure here, I've only heard of one or two. Once again, remedies, they're a big deal. Get your bosses involved. Bottom line is contact the filer and say, don't take any official action until we get this remedied, and then just take it from there.
And we do have a question coming in over the Hangout. And Barbara asks, an employee has their stock diverted into a managed fund. And I think we actually mean managed account. Because the SEC regulates very seriously the use of the word fund, and in order to be a fund, you have to be registered under the Mutual Fund Act. So I think for the purposes of this, we're talking about a managed account, and the account manager chooses the stocks from there without the employee's input. The question is, does the filer have a duty to inform the reviewer if there's a potential problem or if there's a change in the composition of the fund? So I think this goes back to our managed account question is, what is an employee's duty with respect to a managed account if the filer has turned over control of that account to an individual account manager?
Correct. And I think the thing to remember here is that, unfortunately, the filer has ownership of any underlying assets. So there's the potential conflict of interest. However, what I like to hear is that, first off, the reviewer knows about this. So that indicates there's some back and forth between the reviewer and the filer. So is the filer required? Well, when they submit their report, they have to list the underlying assets. It would be great if the filer had such a great relationship with the reviewer that every time the filer looked at that brokerage statement, they saw something new, they would pick up the phone and say, hey, ethics office, I got this. Is it going to be a problem?
I think that gets to one of our major challenges with the managed account is that the filer owns the individual securities in that account.
Correct.
And they're presumed to have knowledge of those individual holdings. And they have an obligation, an affirmative obligation to avoid conflicts with those underlying holdings. So the monitoring challenge becomes a significant one for filers with managed accounts who have account managers that trade without their knowledge. And I think that's why at the highest levels, we have discouraged people from using these kinds of accounts, because we found that it's very time consuming and administratively challenging to stay on top of what's in the account.
Absolutely. And this might be a good opportunity to enter into an ethics agreement with the filer. For example, the filer could say, I will advise my broker to only invest in diversified mutual funds. Or, for example, in our situation where we're dealing with electrical entities or power entities or things like that, we might have our filer say, I will advise my broker to not invest in those types of outside businesses. Once again, there are a lot of options, but I'm thrilled that at least the lines of communication are open. I think that's very positive. Yep. In fact, that's what we aspire to.
And Jennifer, do we have any questions coming through on the phone?
We do not have any questions in the queue at this time.
And we do have one more question on the Hangout. And the question is, do agencies take seriously these obligations to complete the public financial disclosure reports? Do people issue the fines or pursue other administrative sanctions when people fail to report or report timely?
By and large, yes, they do. It's not always voluntary. As I indicated yesterday, one of the functions of OGE is that we actually go out to your agency and we do a review of your ethics program. So yeah, we take it seriously. By and large, agencies take it seriously. And the reason for that is that you don't want your agency showing up in the newspapers with scandals or anything like that. So yeah, agencies do take this seriously. The problem is that the agencies don't always have the funding and the personnel and the expertise. As I indicated to you yesterday, at the Coast Guard, ethics is just another collateral duty that the attorneys in the general law branch have to take care of. And my last tour of duty, the number of attorneys in the general law branch was 2 for the entire Pacific coast. Okay. So we were always busy doing something, and financial disclosure came up twice a year back.
Right, that was before the periodic transaction reporting.
Right. Now it's constant.
Now it's a constant.
But it was just something that you had to deal with then. But hey, we're the Coast Guard. Well, I was the Coast Guard, and we take our duties very, very seriously. And we really want to keep our people out of trouble.
Right. And I think, if you're interested in how OGE treats the issue of habitual late reporting, you can look at some of our program review reports or program review inspections that are available on the website. And you'll see that in agencies where there's a consistent problem of late reporting, our program review team, if they identify that as a weakness, will require agencies to take steps and implement plans to ensure that that is corrected. And there is a follow-up mechanism. You can see some of the follow-up reviews there also about the steps that we take to ensure that agencies that have identified this problem or where we found the problem come into compliance. So, I think that is an area that people take very seriously. Something else that I always like to remind filers is the fine. The fine is a result of late filing. It does not relieve you of the obligation to file. So, you can file late and pay the fine, but you still have to file the necessary reports. Another thing that I wanted to mention, Mark, when we were discussing remedies, is that we do have a recorded broadcast about drafting of ethics agreements, which is sort of how you draft the letters to implement the remedies. So if you're interested in that process, there is a distance learning event available in our library on the max.gov page.
Great. And once again, I indicated this yesterday, but if you guys are new to this, much like I was new to this back in the day, the OGE website is an invaluable source. It just has a ton of information of stuff that you wouldn't even think of. offhand.
Right.
One thing I wanted to reiterate is that we're all in this together, and our main outcome is to keep our employees from getting into trouble. And even though it sounds like it would be a bad thing if OGE made a review of your agency ethics program and said you're not doing enough, that's a pretty good tool to take to head agency management and say, we need more resources to do our job here.
Yeah. No, I think
Fingers crossed that
right.
works. But
yeah, I think that's a good point, is that, some oversight provides us opportunities to strengthen our programs, and where we're chronically under-resourced provides us an opportunity and support to make the case that if there are problems, if there are pieces of the program that aren't working, that they need attention, that we need help, because it's the agency's ethics program, it's not the ethics office's ethics program.
absolutely.
Excellent. And I'm not showing any more questions on the Hangout. Jennifer, do we have any more questions on the telephone?
We do not have any questions on the telephone.
Excellent.
Okay, so I guess we're done here. Thank you for your attention. Just to sum up, what we talked about was financial disclosure and how to review and certify reports. The one main takeaway I hope you get from this is that there's a lot of guidance out there to help you do this.
Yep. Excellent. And the other thing that we want to remind folks is that this is the first of our support for you during this public financial disclosure season. This afternoon, we're going to be building upon that again with the distance learning event at 2 p.m. Eastern time, dealing with some of the new resources. And the advanced practitioner next month will be dedicated to financial disclosure topic as well. So, this isn't the only resource available, but hopefully it is foundational. And actually, we do have one that's and that's it. At what point does a potential future employer become reportable? So that's an agreements and arrangements question.
That's actually kind of interesting because, as we discussed yesterday, a new entrant doesn't have to file until 30 days.
Right.
But boy, that's a really bad scenario.
I think this question is about people who are leaving, who have an arrangement for future employment.
Future employment on the outside, or future employment with the federal government?
I think someone who's leaving the federal government.
Okay.
So that would be reportable as soon as there's an agreement, right?
Correct.
So,
and as we indicated yesterday, PAS types have an even more strict reporting requirement for future outside employment.
And I think as a practical matter, you want to encourage your employees to bring you questions about seeking employment as soon as possible. The reporting requirement, I think, says that once you start negotiating, you have to make the report. But there are challenges and pitfalls that people can fall into well before that. So especially with your senior folks, as they're thinking about moving on from government service in the future after the end of the administration, encourage them to come to you as early as possible in the process, so you can advise them on seeking and negotiating as completely as possible. Because that's a very, very precarious area, and that's another area that will be providing you guys support throughout the summer. So thanks very much, Mark. We really appreciate you joining us and sharing your expertise in public financial disclosure. And thanks to all of our viewers and listeners on the phone. And we do hope you'll join us this afternoon and next week for our further presentations. Thank you.
Thank you.